What's going on, YouTube? Welcome to The Point. I'm your host, Seth Walt, and today, Bryan Kohberger's actions are speaking louder than his words. So let's talk about it. First off, if you're a returning viewer, I appreciate your support. Go on and leave me a like, give me a comment, let me know how I'm doing, let me know what you think about this video. If you're a new viewer, welcome to The Point. If you got a comment on what I say, or you disagree with what I say, feel free to let me know. Nobody's gonna jump down your throat here. I like all opinions and all views, and honestly, if you can't sit there and handle a discussion about a statement you made, you probably made a weak statement to begin with. But let's talk about what's going on with all these court filings that started popping up around the 25th to now. We all remember when Bryan Kohberger's name was first announced in this case. Everybody ran to the internet to dig up anything and everything they could on him. And since that point, almost every single piece of news coverage, YouTube video, article, network, whatever, has painted a very specific picture. I can honestly say I've been covering this case pretty unbiased. More unbiased than most. In fact, my video about him being innocent until proven guilty, it did really good. There were a lot of views. Not as many likes and not as many subscribers, so it seemed to me a lot of people don't agree with constitutional freedoms. But let's talk about another side of this. His defense has been filing motions since the onset of this case. But starting around the 25th and to now, we've gotten some really interesting motions filed on his behalf. Let's start with this motion to dismiss the indictment from the grand jury. Comes now Bryan C. Kohberger, buying through their attorney, J. Weston Logsdon, Chief Deputy Litigation, and hereby moves this honorable court for an order either dismissing the indictment in this matter or to treat it as a presentment and remand for a preliminary hearing before a magistrate. This motion is made on the grounds that the grand jury was misled as to the standard of proof required for an indictment. And when you go read through this motion to dismiss the indictment of the grand jury, they state several cases, statements going all the way back to the mid-1800s as reasons for stating why Bryan Kohberger's grand jury hearing was unjust. Now listen, I've been pretty fair about this. Been pretty unbiased, to be perfectly honest with you, at the detriment of my subscriber count. Let's just call it like I see it. If I'd have made a video stating why Bryan Kohberger was guilty and all the reasons he was guilty, I'd probably have significantly more subscribers. But being upfront, being honest, trying to give an honest point of view, that's the way I'm going to work this. And if it doesn't work, it doesn't work, whatever. But everybody, when Bryan Kohberger was first charged, remembers this statement from his public defender in Pennsylvania.
This procedural matter, you're not the person who will be defending him at trial, presumably. But has he reacted to the charges at all? One can imagine being accused of something like this and saying, wait, where did this come from? Why are they coming after me? Have you seen any kind of that behavior from him?
It is a little out of character. He said, this is not him. He believes he's going to be exonerated. That's what he believes. Those were his words.
So he is eager to prove his innocence. This is a coffee video, trust me. So if he's eager to prove his innocence, why are all these motions being filed? Now, the grand jury is sealed. We don't know what was said. We don't know how it was said. We don't know what evidence was presented, and we don't know who came to testify. We can have a general idea that several of those officers involved in that arrest affidavit were called. It's probably a safe assumption that the two surviving roommates had to make some statements. But here we are, and they're trying to dismiss the whole thing based off what? 962 legal precedents, 1,860 something, statements. I mean, calm down, John Adams. You ain't about that life. But let's get to the conclusion, though. Over 150 years ago, Idaho joined the state of California in adopting the field code, thereby adopting reforms to the grand jury system intended to restore to that system its function as a bulwark for freedom. The strange history that follows in this state, just as every other state with the same statutory scheme, is both tragic and unconstitutional. No court had the power to decide that the legislator had made it too hard for grand juries to do their work and change the sufficiency of evidence required to indict. Mr. Kohberger is asking this court to recognize the long string of error that led us here and give back the people of this state the protections they are owed. The indictment in this matter should be dismissed or remanded for a preliminary hearing. Dismissed or remanded for a preliminary hearing, so they want to take this thing all the way back to square one. And do what? The defense has all the evidence. The state has all the evidence they have. The judge has ruled when this evidence comes in, it goes to the defense. But here we are with the defense saying some kind of nonsense, Revolutionary War crap. Like I said, calm down, John Adams. A quadruple passing of individuals is not the time to make a constitutional stand. I mean, let's just call it like it is. This is not the time to have a Boston Tea Party. But things get weirder here. It had came across the news. I did a quick short on it. And I was initially excited because when you have an alibi, it can prove you were not where you're being accused of being. But the headline was misleading. I'll pull it up for you. Let's take a look at a couple things. Comes now, Bryan C. Kohberger, buying through his attorney of record, Ann C. Taylor, public defender, and hereby files notice in response to the demand for an alibi in compliance with Idaho Code 19-519. She goes on to state that Mr. Kohberger preserves his constitutional right to silence as well as to testify on his own behalf. Mr. Kohberger stands firm on his constitutional right as well as the statutory recognition of that right. Noteworthy is that an alibi indicates a line of proof by which the defendant attempts to show that he could not have committed the crime of which he is accused because he was elsewhere at that time. A defendant's denial of the charges against him does not constitute an alibi, but as soon as he offers evidence that he was at some place other than where the crime of which he is charged was committed, he is raising the alibi defense. Mr. Kohberger's defense team continues investigating and preparing his case. Evidence corroborating Mr. Kohberger being at a location other than the King Road address will be disclosed pursuant to discovery and evidentiary rules as well as statutory requirements. It is anticipated this evidence may be offered by way of cross-examination of witnesses produced by the state as well as calling expert witnesses. So on the surface, my initial thoughts were okay. He was somewhere else, and he's going to make this statement, and he has a right to make this statement. And yes, he does, but he has to do it in a certain way. The state has responded to what Bryan Kohberger's defense put out for his alibi. Comes now the state of Idaho buying through the Latah County prosecuting attorney and respectfully moves to court for an order compelling the defense to comply in full with Idaho Code 19-519 and ICR 12.1 and provide the state with notice of any alibi that may be offered herein, said notice to include the specific place or places at which the defendant claims to have been at the time of the incidents in this case, and the names and addresses of all witnesses upon whom the defendant intends to rely on to establish such alibi. As the court file reflects, the state filed its request for discovery disclosure alibi demand on May 23, 2023, and served the defense on that same date. The parties subsequently stipulated to extend the statutory time for the defendant to provide notice of alibi and comply with Idaho Code 19-519 and ICR 12.1 to July 24, 2023. On July 24, 2023, the defendant filed a notice of defendant's response to state's alibi demand. This document does not comply with the requirements of Idaho Code 19-519 and ICR 12.1 in that it does not specify a place or places at which the defendant claims to have been at the time of the offenses herein, nor does it provide names and addresses of witnesses upon whom the defendant intends to rely. But you skip down a little further. They do give a slight out if the defense does choose to provide an alibi. And it reads this: based on above, the state respectfully praised the court for an order compelling the defendant to comply in full with said Idaho codes by filing a notice specifying where the defendant claims to have been at the time of the alleged offenses and the names and addresses of the witnesses whose testimony will support the defendant's alibi. Given the time constraints, the state prays that the court direct the defendant to comply no later than 10 days from the date of the court's order, and that the state be allowed, pursuant to those Idaho codes, to provide the defense written notice of names and addresses of witnesses who the state intends to rely on to establish the defendant's presence at the scene of the offenses, and any other witnesses to be relied on to rebut testimony of any of the defendant's alibi witnesses no less than 10 days before the trial. Alternatively, the state prays for an order of this court pursuant to those Idaho codes prohibiting the defendant from presenting any evidence, whether by direct or cross-examination, in support of any claimed alibi other than from the defendant himself. So as you can see, the state is saying, you're not giving us an alibi. You're stating that we will have an alibi at some point, and it might come up during the trial, and we're not going to tell you about it. And in all fairness, like Bryan Kohberger has rights, the state has rights too. You can go look those codes they're referring to. For the alibi to be valid, you have to give places, names, addresses, times, all that stuff. You can't just sit there and say, I'm going to give you an alibi when it comes up in trial, and it might be during cross-examination. You're skewing the cards, towards one side over the other. And the trial is supposed to be fair. It's supposed to be fact-based. That's why everybody has access to everything. There's no hidden tricks here. That seems to me to be the case for what the defense is doing. They're trying to play games here. That's what I'm seeing. It is well known that what they presented was not an alibi. It was a statement of intent to have an alibi, but that is not an alibi. And it's absolute nonsense to be filing that. In fact, I would almost wonder that what's going on right now may be more of a case of overlording. I'm not sure, but it might be. I mean, it seems to me they're more concerned about tying down the court system right now with these constant motions and constant extensions rather than what we were told from the beginning. My client is eager to exonerate himself of these charges, but they are dragging it out. In this particular instance, I got to side with the state on it, and I got to know if you think I'm right or wrong. Do you side with the state here, or are you still with the defense? You know, I'm all for fairness and giving everybody their due process. But to try to take this thing all the way back to the beginning, based off ancient England rules circa 936 or some sort of 1863 law state. I mean, come on. You know, if you're trying to paint the picture of innocence here, in my own personal opinion, that defense needs to grab a new brush. This is not reading like the actions of an innocent man right now. Just at the optics of it. He was supposed to provide an alibi. He got the extension to provide an alibi. And then they gave an intent to give an alibi during the court. But that is not what the rules state. The defense cannot just sit there and pull an ace out of their sleeve and say, oh, we got this witness over here. And they can corroborate everything, proving he didn't do it. Because the prosecution hadn't had time to read those statements, prepare for cross-examination, to check to even see if it's valid. But I'm curious about your thoughts. I'm curious about your input. Like I say, I've been pretty fair and unbiased during this whole trial, which is what he deserves, unbiased coverage. But like I said at the beginning, you know, actions speak louder than words. And right now, it's looking like they're just trying to tie everything down, and I don't honestly see how this goes to trial in October at this rate. I don't see it. They're still arguing over stuff from months ago. And listen, the state has said, if you don't want to provide an alibi, that's fine. You can get on the stand and tell us what your alibi is. And we'll see how you feel about your right to remain silent. But I'm curious about your thoughts. I appreciate your time. I appreciate you being here. And I'll catch you in the next one.